Hi, I'm John McGowan. I'm the General Secretary of the Social Workers Union. Good evening and welcome to another SWU webinar where you as social workers get the opportunity to ask employment-based questions. And it's great once more to see so many people registered, and I can see a large number of attendees for tonight on screen. So thank you for giving up your evening, I appreciate that. I'm hopeful that we will get through a lot of questions this evening, and do remember that the advice offered for this session is as of today's date, which is the 29th of March 2022. The event, of course, has been recorded and it will be available to review and share very soon. Indeed, the last recording reached over 1,000 views, so thank you for your interest in this webinar. Working behind the scenes are the talented Sean and Joanne, so thank you, Sean and Joanne, for giving up your early evening. I will now take you through some of the housekeeping for this webinar. Please ask any questions in the live chat box, which is to the right of the screen, and Sean and Joanne will make me aware of them to share with the panel. My advice really is to keep comments brief and non-identification factors in any message, and that's obviously to represent confidentiality. Before I introduce the panel, I just want to emphasise the need to join a trade union. Of course, I keep on saying this, but I'm biased and would always recommend the only specialist social work union, which of course is SWU. And SWU working with BASWA is indeed a terrific collaboration for the social work community. And in particular, I'm delighted that the membership of SWU continues to grow, and we're now getting close to 16,000 paid members in the union. We are more than just skilled representation, and we do that very well, the representation, but please do see the comments box for info on our campaign fund and also the SWU University assignment, just to name a few of our promotions. So why would you not want to join a specialist union, I ask myself. So now over to the most important people in this webinar, and I'll ask each panel member to introduce themselves. Maybe starting with you, Paul, would you like to introduce yourself?
Thanks, John. Thanks for inviting me along this evening. My name is Paul Scholey. I'm a partner at Moorish Solicitors. We're West Yorkshire based, but we act throughout the UK for about 25 trade unions and associations, and I'm an employment lawyer for my day job.
Thank you, Paul. I appreciate that. And over to you, Laura, for your introduction.
Hello there. Yes, my name is Laura Sheridan. I'm one of the members of our advice and representation team, working as a trade union official for SWU on a daily basis.
Thank you. And as I said, keep the questions coming in. There's a few ones that have came in earlier on from participants, so thank you very much. And Paul, I'll maybe get us started. I'll ask you the first one since you're closer to my screen, and it's my employer has given me a negative reference. I have lost a job offer as a result. Is there anything I can do about this? So this person's received a negative reference and he's lost a job offer. So any advice on that, Paul?
Thanks, John. Well, there are various things to say about it. The first thing to say, and that might surprise some people, is that your employer, as a rule, is not obliged to give you a reference at all. Many employers do, but it's not a legal requirement. There's no right to a reference. But if an employer does choose to give you a reference, then the law says that that reference should be truthful and reasonably accurate. And so this question assumes that the reference that's been given is untruthful in some way, and that might give rise to a claim for what we lawyers call misrepresentation. But these claims are not easy. We've pursued dozens over the last few years, but we've succeeded with fewer than that. And there are various problems with them. The first is the problem of proof. Many employers who give a bad reference are not doing so in the form of a letter or an email that you can get your hands on. The thing is either done privately or perhaps even by telephone verbally. So proving that an inaccurate and deliberately misleading or negligently misleading reference has been given is the first hurdle that you'll have to get over. Secondly, you'll have to show that it made the difference. So ideally, you need the new employer who would have employed you to say, yes, they received this bad reference and that's why they didn't employ you, because the argument can be made, well, you might not have got the job anyway. And if you do get a different job, then the reality is you've probably no loss arising from the negligent or fraudulent reference in any event. So lots of hurdles to jump over. Yes, potentially there's a legal remedy, but not straightforward. Get advice from your union if you're a member as soon as you can about this. See what evidence you can collect. If the employer who's turned you down is prepared to talk to you to say this is why I turned you down and this is what I was told about you, then great, and see if you can get that committed to writing. But yeah, potentially a claim, but tricky.
Thank you, Paul. As clear as ever. And so, Laura, is anything you want to add to that? Has it happened to you within the A&R team?
Yeah, I mean, I think for me, Paul's touched very much on the legal side of things, and I think it was about, I suppose, from my point of view, talking about the practicalities that we try and offer advice-wise to members to try and avoid the negative reference situation occurring in the first place. So quite often when people are, when a negative reference occurs, there's been a difficult exit from an employment situation for whatever reason. So sometimes people have an inkling or a concern that they might not get the best reference. And in social work, if you don't get a reference from your last employer, you're not going to get a job. So it's really important that you try and get that advice if you think that's possibly going to happen. So we will talk to our members about trying to have a conversation with the manager before you leave about, you know, what kind of reference are you likely to give me? Ask them to provide you a copy of that potential reference that they're going to send to people in writing before you. Now they won't always necessarily give you that, but it's about having those conversations and seeing if you can sort out the reference issue before you go. And then we can sometimes assist members in advising them as to how you can perhaps try to, if you've got that reference and you know it's not, you know, ideal and you're going to struggle to get work, actually having those negotiations with your employer, discussing what's factually correct and what isn't, and we can support people with that, and we can offer representation with that, and we do sometimes manage to get those, you know, have those discussions and get those references amended and more suitable to be able to, you know, enable people to secure future employment. But it all depends on what's in the reference and what has occurred, you know, up until someone leaving, because they can put factually correct information on a reference as well. So it's about having those conversations, I think, as early as possible, so we can support, you know, our team can support as, you know, as much as possible to prevent that reference going out almost, because once it's gone, it's done the damage. So try and get in there sooner rather than later, rather than having to go down a legal route, is what I would say, because it's not an easy one to go down once that reference has been issued.
Thank you, Laura. Quality as ever. So since I've got you on the screen, please do keep the questions coming in. I appreciate that. And I'll just look to my screen here. It says, I'll ask you this one, Laura, if you don't mind. It says, what are your rights with regards to a secondment for your development? My manager stopped my application as there was no backfill from my post. So what are your rights with regards to a secondment for your development? Are you okay with that one, Laura?
Yeah, I mean, Paul may correct me on this one, but as far as I'm aware, there's no particular legal right to be sent on a secondment from any employment. I think your substantive contract is your substantive contract, and that's your, you know, posting your position. So if you're offered a secondment and it falls through for any reason, and very often we'll get kind of feedback that it's to do with, you know, they're not able to release the staff because the team are short of staff to be able to go and do it. It's quite a difficult one because there's technically no real legal right for you to be able to do that, unless of course they have altered your contract and it's been offered properly and formally and you're moving on to another position, but then in which case it's not technically a secondment. So in terms of an actual formal legal right to be able to go on secondment, unless there's something in your contract that says that you're able to do that and it's part of your contract, I think it's difficult to pursue it. It's again more about having those conversations with your manager in terms of, you know, this secondment is really important to me for these reasons. Are there any practical solutions we can do to try and fill that post? But you don't have an automatic right to go off on secondment into another position.
Thank you, Laura. And is anything you want to add to that, Paul?
No, I just I agree with what Laura said, that legally chances are that you've got no entitlement to be sent on as a secondment. It's a question about what you can negotiate, what you can agree with your employer.
Thank you. So thank you for that one. So we'll move on to, I'm looking at the screen now. So Paul, if you don't mind answering this one, it's a fairly long one, so I'll try to articulate it the best way I can. It says that the social worker, a social worker is currently on sick leave awaiting surgery for a long-term condition. So this person's waiting for surgery for a long-term condition, Both the GP and OH have recommended part-time working no longer than 20 hours a week until the surgery has been concluded, but despite having free meetings to try to facilitate a back-to-work plan, the employer has flatly refused to consider the part-time working request. So here's a request for health reasons to go down in hours, but it's been flatly refused. So any thoughts there on that one, Paul?
Right, so this looks classically like that it might be a case of disability discrimination. So let's look at what the law says about what a disability is. The definition is not the same as the definition used to get, say, a disabled sticker for your car. And the Equality Act 2010 says that you're disabled if you have a long-term physical or mental impairment that has a substantial effect on your ability to carry out normal day-to-day activities. So there are 3 or 4 parts to that test, and you have to tick every box if you're going to be classified for discrimination purposes as disabled. The chances are that if this social worker's on sick leave awaiting surgery, then they're going to tick at least some of the boxes for the definition. It's unlikely, for example, that their condition does not substantially affect their normal day-to-day activities if they're off sick. So that part of it is probably going to be satisfied. The trickier issue will be whether the condition is long-term. It's described as long-term, and that might be sufficient, but remember, it's whether the effect on normal day-to-day activities is long-term. So if this person wasn't affected in a significant way for 10 years, say, but in the last 3 months has been off sick, then they may not qualify as disabled, because the period of substantial effect has to be 12 months or more. So provided that we're off sick for 9-12 months, or if it looks like we'll be off sick for that period of time, then we'll prove disability. And the question is, what rights then arise? And the obvious one is that there's a duty in law for employers to consider what are called reasonable adjustments. So as an employee, you approach your employer and you say, look, here's my disability. These are the issues that it creates for me, and I think you can make adjustments to my job to help me work in these ways. And classically, one of those adjustments might be a change to working hours. So in this case, the suggestion is, can I reduce to part-time hours? And that's certainly potentially a reasonable adjustment, and at the very least, your employer would have to consider it. And in the example you've given, despite a number of meetings, the employer has refused to go along with this, so the employer will need to justify that refusal. It's not just you that is saying in this case that you need this adjustment. The GP is saying the same, occupational health is saying the same, so the employer's up against it, in my view, but might be able to show that operationally, and Laura touched on this in relation to the question of secondments, that operationally they cannot work with somebody on a part-time basis. Now, 20 years ago, that was an argument often made by employers who didn't want to allow women to return to work after maternity leave on a part-time basis. Tribunals these days give that argument fairly short shrift. The reality is there are lots of people out there looking to work part-time. There are people looking to job share, and I think an employer has to go quite a long way to prove that it's not reasonably practical for them to make arrangements to put somebody onto part-time working, especially where that desire to work part-time is not merely a wish to change work-life balance, but is about a disability that gives rise to this duty, as I've said, to make reasonable adjustments. If the employer won't grant your request, then the next step will be to pursue the thing as a grievance, and after that to look, if necessary, at tribunal proceedings. But get advice at an early stage. If you're a union member, then your rep's the first place to start. Get advice for this reason. There's a time limit in cases for disability discrimination. And in fact, in most employment law cases, the time limit is 3 months less 1 day. And if you don't take action to start the tribunal process rolling within 3 months less a day of the day that the act we're concerned with happened, then you may be out of time to bring the claim. And that means you might never be able to bring the claim in the future. So get advice as soon as you can, And if nothing else, get that date in the diary and be aware that you might need to take formal legal action sooner rather than later.
Thank you, Paul. And Laura, I suppose I didn't ask you to expand on that. There's a question that's came in live as well. And it's quite similar to that. And it says, I've submitted a flexible working request to compress to a 4-day working week. My employer has declined, stating they don't have the staff. However, I know that's not true. There is more staff than when I went on leave. How much can you challenge these decisions? And is it worth it? Are you okay with that, Laura? Or?
Yeah, that's fine. I mean, I think the first thing I would say is that if we get this kind of call coming in when we do our duty advice service, I'd be asking quite a few more questions around this in terms of, you know, what reasons did you give for your 4-day working week? So, for example, you know, kind of moving on from the last question, is there a health condition or disability that would mean that it makes your condition more manageable if your hours are more compressed? You know, I know I've represented some people who have found that if they do the 4 days rather than the 5, they're able to recover on the 5th day if they have a condition that requires them to recover, and it enables them to work. So that's the one thing. Is it because of childcare, you know, needs? It doesn't have to be for any of those reasons, but sometimes it can help to strengthen that case and that flexible working request if you're very clear on what your reasons are for that request. I think to kind of move forward, I mean, what I would say is every employee, when they've worked for an employer for a qualifying period of time, off the top of my head, I think it's 26 weeks, but I need to double check my book before I confirm that, but I'm sure it's 26 weeks. But once you've worked for an employer for a qualifying period of time, everyone has the statutory right to request flexible working. And actually, then it's for the employer to, because they have a legal duty to consider that request, and they have to give a valid reason as to why, if they're not going to grant it, a valid reason as to why. They can't just say no. And there is actually a list in the Employment Rights Act of the reasons that they can give. The one that we often see, which is pretty much the reason that's being given here, is for business reasons, the effective running of the business, basically, which in this case would be the effective running of whatever service this person is working in. And quite often what we see is an employer just say, no, we don't have the staff, which to me isn't quite, you need to justify it more than that. You know, why can we not cover this on this day? You know, a more justifiable reason. So what you do have the right to do, and you know, under the flexible working policy, there should be the right to appeal the decision to decline the flexible working request. And I would say to anybody, you have that right to appeal it, you can appeal it, and then somebody else should look at that appeal, and they need to, again, kind of offer that justification as to why they can't facilitate it. It may be that there's a genuine business need, but they need to demonstrate that, really. So you don't have an automatic legal right to work that 4-day week, but you do have the right to request it, and your employer has a duty to, a legal duty to consider it seriously and not just instantly think, no, we can't do that. So yeah, in terms of how much you can challenge it, you can challenge it. Is it worth it? Depends how much you want that 4-day week, I suppose, is the answer to that one. And if there is evidence that the employer really hasn't considered it properly, you do have a right to bring a claim in an employment tribunal for failure to reasonably consider a flexible working request. That's the last resort, I would say, because employment tribunal claims are never easy, and if you can resolve it without having to go down that route, it's always easier. The one thing I would say with this case and the previous case, if you're a member of a union and you go into these meetings, flexible working meetings, sickness meetings, ask for a union rep to go with you. Don't go to them on your own. The more support, advice and representation you can get through these things, the better, and often the more successful these situations are.
Thank you, Laura and Paul, for the 2 questions there. We've had a couple of questions, and there's been one really long one. So again, if it's hard to really read out, so to read a long one out like that. So if it can be condensed, or if you're a SWU member, maybe perhaps it's something you can access in so an actual duty session with A&R. But again, it's a really long one to to read out. So, but thanks for your interest there. Laura, I suppose why I've got you there on the screen, if you don't mind, there is the question is, can menopause be considered as a disability? Are you okay with that?
Yeah, that's fine. I mean, I think Paul outlined the statutory definition of disability earlier, so under the Equality Act. So menopause on its own wouldn't automatically be considered a disability. As kind of repeating what Paul said earlier, under the Equality Act, if you're looking at the definition of disability, you'd need to have a physical or mental impairment that has a substantial and long-term adverse effect on your ability to carry out normal day-to-day activities. So you're looking at two elements there. Do you have a form of physical or mental impairment? Potentially menopause symptoms can cause both physical and mental difficulties in terms of, physical symptoms, concentration issues, all of those kind of things I know can be symptoms of the menopause. And then it's looking at actually how substantial those symptoms are and how much of an impact they have on that person's ability to carry out normal day-to-day activities. So, if they have a minimal impact on someone's ability to carry out normal day-to-day activities, then it's not likely to be considered a disability. It all really depends on how the actual menopause is impacting on that person, and what symptoms that person is suffering and how long those symptoms have lasted or are likely to last for it to be determined whether or not it is a disability. So again, I think it's about kind of thinking about that statutory definition to see whether or not the symptoms would fit in with that statutory definition, but also having a conversation, with, again, seek advice from us in terms of what support can be put in place for the menopause, because a lot of employers are getting a little bit more on the ball with it now, and are putting particular policies in place to support those who are going through the menopause. So I think it's about, kind of looking if your employer does have any policies, and if you need any support, with that side of things, if you do believe that your menopause symptoms would be or could mean that they would be classed as a disability, and you feel you're suffering discrimination at work as a result of that, give us a call. Let's talk through it, and we'll identify whether or not we think it is and what we can do to support you to challenge any discrimination you might be facing.
Thanks, Laura. Great advice there. And Paul, anything to add to that answer?
I think Laura's covered all the main points there. Certainly the tribunals are now hearing cases where the disability in question is menopause related. As Laura says, it's not the way to go to simply say, I have issues in relation to the menopause, therefore I'm disabled. The way to approach it is to identify the underlying symptoms that cause the problems, the physical and mental issues that together constitute the menopausal problems that you're facing in your home or work life. And several tribunals have now shown that they're more than happy to look at those individual symptoms or conditions and to say, yes, these on their own or taken together amount to a disability. We don't care whether they're classified together as the menopause. We're prepared to look individually at how they affect the person in question. And if the effect is long-term and substantial, then certainly tribunals are finding that people can benefit here from disability discrimination protection.
Thank you, Paul. And it was just to remind everyone that if you are listening in and you have an issue that, if you're not a BASW or a SWU member, you can join, you'll still be able to access advice. There's a short qualifying period before representation, but if you're thinking about it and you're listening to this, to this webinar and you want to be a member, then it's that service is available and the access to, to some quality specialist staff there within ENR. So something to consider. So thanks for the answer regarding menopause. Keep the questions coming in. We've got a few ones in already. So Paul, I'll maybe ask you this. Here's a COVID question. We're down the list now. So and this is the first COVID one. So I'll maybe present it to you. So it's, my employer is still insisting that we should wear a mask in the office despite the latest government guidance. Can I refuse to wear a mask? Are you okay with that one, Paul?
Yeah, happy to take that. Thanks, John. So this has been obviously an area that's created a very substantial number of complaints in the workplace, and many of those now have led to tribunal cases. And in the last few months, we're starting to see the first few of those cases coming through and decisions been made. So we're starting to get a feel for how the tribunal is dealing with this sort of complaint. And in this case, the example you've given, John, somebody saying, do I have an obligation to wear a mask?
Yeah.
But the thing
No,
can
they
be
said,
turned,
they said, can I refuse to wear a mask?
but it can be turned on its head as well. So in some cases, the advice is, I want to wear a mask, and I'm worried that my employer is not requiring other people to wear a mask. So the issue can arise from both sides of the line of concern, if you like. And I think the position currently is it depends, and the employer needs to conduct a proper risk assessment to look at all the factors that affect its employees in the workplace, and to take a sensible view, probably informed by guidance from, say, occupational health, about what the right approach is, despite the government guidance. Because the truth is that government guidance, all know, the number of cases of COVID remains very high, and the figures this week, certainly for parts of London, are fairly alarming. And against that background, even if the government's saying you no longer are required to absent yourself from work, you're no longer required to wear a mask in the office, nevertheless, an employer, in my view, can reasonably say, I have a duty to take care of the health and safety of all my employees, and given the threat that COVID represents and the proximity in which my workers work close to each other in their office, I can require them to take COVID prophylactic steps to improve the health and safety environment in the office. How far does that go? Is it going to involve, for example, requiring people to be vaccinated? And the answer is, in all of these questions, it's going to depend on the type of work that you do, the type of office you work in, the risks that are presented by all of the factors in relation to your job, whether or not you, and again, this is where discrimination might come back into the question, whether or not you suffer from a disability of some description that might render you particularly at risk if you get COVID, whether you might have somebody at home who's particularly at risk, and whether that might make a difference, whether you have a religion or belief that's in play in relation to, for example, vaccination, whether you have a medical condition that renders it difficult or impossible for you to wear a mask under any circumstances. So I'm afraid there's no easy answer to can I refuse to wear a mask. The likely answer is, if your employer goes through the hoops that I've described and makes a reasonable decision based on the evidence, then your employer can probably require you to do what he or she wants. And if you fail to do what they're asking you to do, then you could open yourself up to discipline, or in the end, even dismissal. And we've certainly seen tribunal cases coming through now where individuals have been dismissed for not following an employer's requirements in relation to protection from the pandemic.
Thank you, Paul. And I think I'm right in saying, Laura, I think there's a lot of advice on the Basel webpage regarding, still the advice regarding COVID and the restrictions. And I don't know if you've got anything to add to that, Laura.
There is. I mean, I think the one thing I would say is that it's even still now, it's a never changing situation. It's very, I mean, the guidance as pointed out in the question is that, the government aren't saying we have to wear masks. How that would be viewed if someone refused to in 12 months, 18 months time, if it went to a tribunal, we don't necessarily have that answer, because the situation now is different to what it was 12, 18 months ago, So it's a really tricky one, I think, to advise on these issues as they stand at the moment, because the situation as it is now is the advice would potentially be different to what it would have been 18 months ago, but we're only starting to see those cases coming through from 12 to 18 months ago. So it is a tricky one, and I don't think we have the ultimate easy answer, and only the courts are going to give us the full answer depending on case specific situations, really.
Thank you, Laura. And that's just halfway through the webinar. So already we've answered some detailed questions. So please do keep them coming in. Since I've got you on the screen, Laura, if you don't mind, I'll jump to the next one. I'll look at to see what's came in. And it's could you explain what it means by discrimination by association? Would you be okay with that?
Yep, I can explain that.
Thank you. Explain it to me.
Yes, it's a little bit. It's not complicated. It's just an area of law that's probably not as well known as other areas. So most people have heard of the Equality Act 2010, and under that you've got a number of protected characteristics. Now there's a list of 9, and I always forget 1 or 2, so I'm not going to go through the entire list. You know, the ones that kind of scream out to me at the moment are age, gender reassignment, sex, disability, pregnancy and maternity. So what that means is basically under the Equality Act, or under kind of previous legislation that led up to the Equality Act, it's discrimination is if somebody with one of those protected characteristics is treated unfavourably as a result of that protected characteristic. So this all kind of, the discrimination by association came about by a case that was in 2006, I think it was, which actually progressed all the way to the European courts, in which the claimant actually cared for a disabled son. She had to resign from her job because she wasn't able to get flexible working, and she then brought a claim which was basically effectively a discrimination by association claim. So the European Court actually held that equal treatment wasn't just kind of limited to those who actually themselves have a disability, and that treating a non-disabled employee less favourably or subjecting them to any kind of harassment or detrimental treatment because of their association with a person with a disability is illegal. So from that point of view, you know, the actual Equality Act, the definition of direct discrimination, for example, is that someone's treated a person less favourably because of a protected characteristic. So you don't necessarily have to have that protected characteristic yourself. You could just be associated with that person. So the example, you know, the perfect example of the discrimination by association is the one that I've just given in terms of direct discrimination. You know, if people are carers for someone who has a disability and are unable to get those flexible working hours to be able to care or meet those care needs, there's a potential claim there for discrimination by association. There's also a really interesting one with regards to indirect discrimination, which is another form of discrimination under the Act. Indirect discrimination is when there's a provision or a kind of practice in an organisation that puts a person with a protected characteristic at a particular disadvantage. And the really interesting case with that one was again a European case where there was an electricity supplier in Bulgaria, I think it was installing electricity meters, and he was storing them in a higher height than in other areas, and it was in an area that was predominantly inhabited by people of Roma ethnic origin. So what they were saying was obviously they were doing that because there was this discrimination, that they would assume that the people of Roma ethnic origin would tamper with the meters. Actually, there was a claim brought by a resident of that area who actually wasn't of Roma origin himself, but was actually successful in a claim for indirect associative discrimination. So that's kind of what it is, and they're 2 examples of the kind of areas of law where it's been put into practice, which is actually quite interesting, I think.
Laura, it certainly came across as interesting, so fantastic answer, thank you very much. And Paul, was anything you want to add to that description?
Yeah, the law's been in a state of some flux for a while now in relation to this. The general rule for example, the right to have reasonable adjustments made is that that's a right that relates to your disability, not somebody else's. So getting a change to your hours because of a relative who you look after at home with a disability has been problematic. But interestingly, the Bulgarian case, the Roma case that Laura mentioned, has put that into a slightly different perspective, because we now have a European case that says discrimination should affect people not only who have a certain protected characteristic, but associate with other people who have it. And a tribunal in the UK in the last 3 or 4 months, in fact, has for the first time applied that European decision to uphold a claim for associative discrimination, where historically we felt it was hard to go there, in some cases at least. And we're now waiting for that to be appealed, because it lets the cat out amongst the pigeons in a very clear way, and it gives us an argument that we've not necessarily been able to make in the past. So watch this space. My prediction is that it could go anywhere but it seems to me absolutely sensible that if discrimination protection is to be effective, it needs to affect not just the person with a disability, and that's where this will mainly arise, I think, but the people who are caring for the person with a disability. And unless that protection is extended, then it's not good protection at all.
Thank you, Paul. Another detailed response, and hopefully you all found that answer useful. I'm just going onto the screen now, and Paul, since I've got you there, I'll keep you on for the next question. And it's, if you're okay with that, my employer is looking at a variation of my contract. Do I have any say in this? So somebody's got a variation.
Happy to do that, John. It's a huge issue, so I'll try and keep my answer fairly succinct. Some contracts will say, as part of the contract, and increasingly we're seeing this, they will say something like this: we, the employer, reserve the right to make changes to your contract, and we will notify you in writing within 28 days if we do so. So that's the starting point. Look at your contract and see if the employer is entitled to make changes as an explicit right given to the employer under the contract. You will find, of course, that that right never works both ways. The employee is never entitled to say, I can change the contract to when it suits me, which would solve the problem of wanting to go part-time overnight. But there we go. Can an employer rely on that sort of clause in a contract to make any change at all? Answer, probably not. The courts and tribunals have been careful to say that a unilateral power to vary should be used sparingly. So it might reasonably say that we can make a change to your hours of work from 5 till 5:15 in terms of your finishing time. But if that becomes 5 till 7 p.m, then that's an enormous change that might affect you in all sorts of ways, and the tribunal is less likely to say that the unilateral power to vary is sufficient to warrant such a significant change. But what if the contract doesn't have a provision in relation to variation? Well, then what lots of employers do is they seek to negotiate, firstly, a change. And as we've seen all too recently, on more than one occasion, if they don't get the change agreed that they want, they embark on what's called a fire and rehire process. So they say, I want you to accept a 10% pay cut. I've negotiated with you and you're declining to accept that pay cut. So what I'm going to do is give you your notice. So you're entitled to a month's notice. Here's a month's notice. It expires on the 28th of April. On the 29th of April, here's an offer of a new job, which starts the very day after your old job finishes, and it's on exactly the same terms, but it's 10% less. So there we have fire from the old job, rehire into a new job. And the problem is, if you take the new job, then firstly, you can't complain about the pay cut anymore because it's not a pay cut. You've accepted a new contract on the new rate of pay. And secondly, whilst technically you've been dismissed from the old job and you might have a claim for unfair dismissal, firstly, unfair dismissal is not a terribly good remedy. Secondly, it's limited in value. And thirdly, the biggest part of the value disappears because you immediately have a new job on 90% of what you were earning. So what do you do in those circumstances? Well, you begin again, and I'm not on commission, I promise you, you join a union if you're not a member already. If you are a member, you seek advice at the earliest possible stage. And what the union can look to do, especially if a group of you acts collectively, is firstly bring pressure to bear on the employer not to make the change, or to negotiate so that the change is less substantial, or as a last resort, and this happens more often than you'd think, to negotiate a sweetener, say, or a buyout of terms, so that rather than being fired and rehired, there's at least some compensation on a voluntary basis for a change to your terms and conditions that otherwise you might not want to agree to. So it's a massive subject. I'll stop there, John, but I could write articles on it and have done.
Thank you, Paul. Great information there, and I'll maybe ask you, Laura, for any comments. But I noticed that one of the participants has said that the old local authority contract used to say any other duties that the director or whatever so requires. So I don't know if that's still apparent. But anything to add to that, Laura?
Yeah, you do tend to get the cover it all term at the end of a lot of contracts, don't you? Any other duties, what that means in practice now, I don't think anyone's ever quite sure, but I think Paul's covered it very thoroughly. I would just reiterate, unfortunately I'm not on commission either, but I would say, you know, take a union rep with you to these meetings. You know, the more support you can have from people. We can't work miracles, we can't make the, you know, we can't just turn up and they stop these processes, but we can negotiate things for people and make it as easy as possible. I think if that's the right way of putting it. It's never going to be easy, but we can try and get a decent outcome for people in these situations. So yeah, get in touch with the union, of course our union, because ours is the best, but you know, get in touch, you know, and get that representation.
Thank you, Laura. And before I go on to the next question, we've got 4 questions in, and we've got 20 minutes left. So we've still got room if anybody's got any burning questions, but if not, we'll run with the 4 questions that we've got in. And Laura, since you're on the screen there, the question is, does an employer have to complete a disciplinary or grievance investigation within a certain timescale? So the person's asking about the timescale for a disciplinary. Is that okay, Laura?
Yeah, my simple answer to that would be I wish they did. I genuinely wish they did, because actually it would make things a lot easier for everyone concerned. There is guidance. It's not just guidance, it's a code actually, the ACAS code on disciplinary and grievance procedures, which is a process, a code that sets out what employers are supposed to do when they're carrying out disciplinary or grievance procedures. I can't remember the exact wording in that guidance, but it's something woolly along the lines of investigations or things have to be concluded within a reasonable time period, or something of that line. In my experience, a lot of employers' version of reasonable time periods, particularly in the kind of area that a social worker working in, which is mainly kind of public bodies, their version of reasonable time period is often not my version of a reasonable time period. That code in itself isn't a legal requirement, so you can't bring a claim against your employer because they haven't done a disciplinary investigation within 6 months, for example. So I think there's a misconception sometimes that if someone doesn't follow the code, you can take them to court, but that's not how it is. It's not a piece of legislation. What I would say to people is that piece of legislation, that code does come into play if there is an employment tribunal claim. So if you were dismissed, for example, as a result of a disciplinary process and you bring a claim for unfair dismissal and you're successful in that claim, if the employer hasn't followed the ACAS code, the tribunal can uplift the amount of compensation that's given. So that's where that code itself comes into play. And that's where it makes sense for the employer to follow the code, because it reduces their, you know, the impact on them potentially if there is a claim that's brought. But there's no actual legal duty, you know, requirement for them to follow that in itself.
Thank you, Laura. And anything you want to add from your wisdom, Paul, onto that question?
Laura's covered it. I think I would just add that my experience also, especially in the public sector, is that what constitutes a reasonable period of time for a grievance or disciplinary can run into 6, 9, 12 months fairly easily, which I think most organisations would regard as well beyond reasonable, but there it is. And one of the problems with that is that once it's kind of established and understood that that's how long it takes, then lots of these authorities will rely on that and say, well, look, it takes that long everywhere, so we're not doing anything that's unusual. And the problem then is, what can you actually do about it? Because the employer won't be persuaded usually to stop pursuing the disciplinary just because it's taken a long time. But it can be life-changing. The level of stress with an ongoing disciplinary or an unresolved grievance hanging over your head can be enormous. I'll just add this as a practical point again. If you're pursuing a grievance because of an issue that's happened at work, and in particular, if you've been discriminated against or harassed, or if your employer's made a change to your contract or whatever it is, let me go back to what I said earlier. There are short time limits in employment tribunal cases And you may think, but surely I'll get some extra time if I'm trying to resolve the thing using the internal grievance process. And the answer is probably not. So again, I hate to be too legal about it, but get advice at an early stage, because once your 3 months is up, then the chances are that you're not going to be able to pursue the matter later on, and the internal grievance process will not necessarily extend your time.
Thank you, and thank you, Laura and Paul, for adding to that question. So a few other questions there, and Paul, since you've got you on there, I'll ask this one. So it says, do I have to serve my full notice period, or can this be negotiated? Is that okay, Paul? Is that the form of negotiation there?
Yeah, sure. So your contract will usually stipulate what notice period you can expect to give. Often it might start at a week, going up to a month. In a more senior role, you might be expected to give 3 months or even longer than 3 months notice of your intention to leave. The first thing to say is that it's a contractual obligation. So it's part of an agreement between you and your employer, and any agreement can be renegotiated. So yes, to answer the straightforward question, can it be negotiated? Certainly you can try and negotiate it downwards. And in my experience, a lot of employers will accept a degree of short notice, because I think most employers take the practical approach that if you've got 3 months to work out, it's probably better keeping you for 6 happy weeks than having you there for the full 3 months and being disruptive and difficult because you want to move on. What happens if the employer simply says, no, you've got to work out your full notice period? Well, you've 2 options. You can either bite the bullet and do it, and I think most other employers that you're likely to move to will allow that in most cases, because they're going to expect the same from you when your employment finishes. Or you can say, well, I'm not going to work it, I'm going to walk. What happens in those circumstances? And we do see this with some frequency, and the answer is, well, technically, you're in breach of contract. So technically, your employer can sue you for compensation for breach of contract. Does it happen? No. Realistically speaking, I can't recall the last time I saw an employer try to sue in these circumstances. But again, get advice before you take steps, because there are certain roles and certain positions that, because of their unique nature, might give rise to a potential claim. So one example would be where an employer has to get someone in, say from an agency, to cover your work. And if they're paying the agency £5 an hour more than you, then they could potentially look to reclaim from you the £5 per hour for the balance of the notice period. But again, practically speaking, for a few £100 of the small claims court, is an employer going to do it? Probably not. I think twice about it, probably on a purely practical basis, that if you walk out of your old job to get into your new one sooner, than your new employer might ask the question about what's going to happen to them when it's their turn to be the ones who are getting the notice.
Thank you, Paul. Laura, anything to add from your experience regarding the serving the full notice period?
No, I think Paul's covered it all, to be honest. Thank
you, Paul. So Laura, I'll do the next one to you, and there's 2 other questions after that, so that should probably take us up for a nice time in there. So it says that if I am an agency worker working for a local authority and using an umbrella company, am I employed or self-employed? Are you okay with that, Laura?
I am, yeah, and I think the difficulty with this is that there's not necessarily always a completely straightforward answer with employment status. I think a lot of the time it needs assessing more thoroughly. Generally speaking, when we're talking to social workers who are working for an agency, and they then go kind of what they have is an umbrella company that acts as like technically the umbrella company is the employer, and the agency finds them the work and they get a fee for placing them the work. So they actually normally have some kind of employment contract with the actual umbrella company. But we have seen a couple of unusual situations, and it all comes down to the kind of IR35 provisions that came out a few years ago. And the idea was to kind of prevent the tax loopholes where people were able to kind of own their own companies or work as set up their own limited companies and get through kind of certain loopholes by claiming to be self-employed and reducing tax. So it's quite a complicated situation, I think, and ultimately, if you're classed as an employee, or if you're self-employed, they look at things like, well, actually, are you completely in control of your own work, and are you able to delegate your work, for example? If you're not, and somebody actually controls your work, controls your hours, you're more likely to be employed in some kind of capacity. So if there's an issue around kind of your employment status, and it's something that needs to be looked at, normally it would only be assessed if you were bringing an employment tribunal claim, for example. The courts would look at it in a lot more detail in terms of what your employment status was. Generally speaking, most of the social workers we speak to who are under an umbrella company and working as an agency worker are technically employed by their umbrella company, and it will normally say something to that effect on your contract.
Thank you, Laura. Anything to add to that, Paul, regarding the using an umbrella company?
Just to emphasise Laura's point about how complicated it can be, and to give a really, I think, interesting example of that, it's perfectly possible to have HMRC look at your status and conclude that you're a self-employed person and treat your taxation in the same way, but then to pursue a tribunal case where a tribunal determines that you're an employee as a matter of employment law. So it's like Schrödinger's employee. You're in two different conditions at exactly the same time for the purposes of employment law and tax law. Impossibly difficult stuff, and at the risk of repetition, get advice about it if you're in that situation.
Thanks, Paul. Sounds like a minefield, so thanks for that advice. So I'll keep you there for the next question. So it's how do you support, the person says, how do you support a colleague when you're aware they're being bullied by a manager? However, when this has been raised to senior managers a number of times, it's swept under the table. So someone's saying, how do you support a colleague when they've been bullied by a manager and it's been swept under the carpet? If you don't mind that, Paul.
No, that's a really good question, John, and it's something that we see all too often. And I'm sure Laura will come in and talk about the practical aspects of getting support through your union and the representation service. So I won't touch on that, although it's important. I want to just look at the legal side of it to say how bad the law is at helping employees in this situation. If the bullying that you're suffering is related to one of the protected characteristics that Laura described earlier, so sex, race, disability, marital status, religion or belief, sexual orientation, and so on, then you've got a right to bring a claim for harassment under the Equality Act. And those rights are really strong, and tribunals take those claims really seriously, and the compensation you can receive is substantial and tends to make employers think twice before they allow it to continue. But the problem is, in lots and lots of cases, bullying at work isn't related to a protected characteristic. It's a white man bullying a white man, say, with no disability or other factor in play. What can you do in those circumstances? Well, you raise it with management, you can pursue it as a grievance, but in this case, the example given is it's been swept under the table a few times. What next? And the answer, in short and shockingly, is legally not much. The real step that you can take to bring it to an end is to leave. And if you leave in certain circumstances where you've been badly bullied, then that might amount to what we lawyers call constructive unfair dismissal. So a constructive dismissal claim can arise where your employer breaches your contract in such a serious way that you can no longer be expected to continue to work there. Those claims are really hard to pursue, and the money that you'll receive if you succeed in them is not terrific necessarily, but more to the point, to even start the process, you have to quit. You've got to leave the job that you're in, that you're supposed to be protected by your employer, from colleagues who might bully you. The law's putting the onus on you to walk away from your source of income, and what you're left with is a potential claim, and any lawyer or union rep will tell you that a constructive dismissal claim is always hard to pursue, and you're really going to leave employment with just the possibility of a difficult claim and nothing to put money on the table next month. It's not good. We need an improvement, it seems to me, to the sort of support that people get when they're bullied at work. And there was a suggestion 20 years ago by a member of the House of Lords that we should have what was called then a dignity at work bill that would give you a right, regardless of protected characteristic, to bring a claim in a tribunal to say my dignity at work has been undermined by this bullying. The Equality Act's not engaged, but nevertheless, my life's been made a misery by it. The law never got anywhere. I don't think it's about currently to get anywhere. Some people try to make use of a piece of legislation called the Protection from Harassment Act, but actually that's not a good route in 99.9% of cases. It's really designed to tackle criminal stalking behaviour, and it doesn't fit easily with the work environment. So the answer is not good. The answer is that from a legal point of view, there's not a lot you can do. So I'm going to go back, of course, and say what you need to do is talk to your union. I'm sure Laura can touch on that.
Thank you, Paul. And Laura, do you have a quick response to that? And I'll squeeze in another question afterwards, if so.
Yeah, I do. I think, yeah, Paul is right. It's so frustrating, I think, as union reps, because there isn't legislation to protect people from bullying, which is shocking, really. I think the question was around what can we do as colleagues to support our colleague who's being bullied. I suppose from a practical union rep point of view, if that person chose to raise a grievance about the bullying that they'd suffered and a formal grievance, there may be a dignity at work policy that they can go down that route and raise a complaint. These staff members could support that by, acting as witnesses in that situation and giving witness statements, which would help to support that grievance. Wouldn't necessarily, if this person's being bullied, it's not going to necessarily make a difference, but I think it's about offering that support. And if we have staff that are prepared to stand up for their colleagues, it makes a huge difference in these situations. So, yeah, get people to get in touch with us and have those conversations, and we will happily kind of, support people through that.
Thank you, Laura. And this will really have to be quick. We've got 3 minutes left. I don't know if we can tackle it, but it says, I was dismissed due to failing to pass my ASYE. I have dyslexia and didn't have the equipment support I need in place. Do I have any rights to challenge my dismissal? Are you okay with that quickly, Laura?
Yeah, I mean, I think potentially, I'd want to know more information in terms of were your employer aware of your dyslexia, was your employer aware of the equipment that you needed, and how long did it take them to put that equipment in place? What was it in place at all during your time at that work? So all of those questions would need to be asked. But if you haven't had that stuff in place and you then lost your job, because normally an employer has a requirement to pass the ASYE, and if you don't, or quite often they do, that then they'll dismiss you at the end. If they haven't put adjustments in place that they know you need, potentially, then yeah, there could be a disability discrimination claim. So get in touch with us, because we need to explore that with you further.
Well, a perfect answer and great time. And Paul, just anything to add to the last minute there, or were you happy with that?
No, I endorse that answer entirely.
There you go. So on behalf of SWU, I'd like to thank Laura and Paul for the wisdom, the knowledge, and you can see the high level of skills they've got. Behind the scenes, I'd like to thank Sean and Joanne. This has been Talk to SWU webinar, and I look forward to doing another one soon. So thank you for your support, and good night, everyone. Goodbye now.